Okay, welcome to Module 8, um, in which we will explore Chapter 2 in the Nutshell series Healthcare Law and Ethics. Last week we talked a little bit about access to the healthcare system through the provision of health care insurance. Today we'll talk about the most basic legal aspect of healthcare law, which is the treatment relationship. And in so doing, we'll touch on the duty of physicians to accept and treat patients. We'll discuss the corresponding duty of hospitals to accept and treat patients, especially in the emergency context. And we'll talk about uh, the legal duties of healthcare providers to their patients, the fiduciary duty of trust, the duty of confidentiality, and the duty to provide informed consent. So let's begin with the duty to accept and treat patients. Generally, in the common law, which is the law that existed before there were any statutes or regulations governing the relationship, doctors were held to what we called a no duty rule. Another way of saying it is that they were not held to have a duty to treat or accept patients. Under the common law, a doctor could choose to treat or not treat as he or she so wished, and could determine under which conditions they would accept and treat patients. A quick look at the Hippocratic Oath, which you're all familiar with and which is attached to the module as a resource, um, uh, will show you that not even the Hippocratic Oath imposes a duty on a physician to treat. The early case here mentioned in your text was Hurley versus Eddingfield, which came out of Indiana at the turn of the 20th century. And it held that there's no duty to treat imposed on a doctor who had been the family doctor, had treated members of the family in the past, who knew that the patient was critically ill and was available, whereas other doctors, to his knowledge, were not available, and was even offered payment. But even under these circumstances, the court held that that doctor had the right to refuse to treat that patient because there was no specific treatment relationship established between the doctor and the patient. Another case, a harder one in Texas in 1969, called Childs versus Weiss, emphasizes this point. This involved the refusal of a doctor to treat a young African American girl who was pregnant, presenting in the ER with labor pains and a bloody show. The baby was delivered and passed away 12 hours later. Doctor refused to treat. The court held that since the doctor had no relationship with this patient, the doctor had no duty to treat. Although this is a lamentable result given what the law was at that time in 1969 under the common law, the ruling is technically correct. The doctor had no relationship with the patient and was not obligated by law or by his oath to treat. As I mentioned before, the Hippocratic Oath does not obligate a doctor to treat because it presupposes that there's a relationship already established. AMA rules do not require treatment except in some circumstances in emergencies. So, how is the doctor patient relationship formed? Well, the relationship between a doctor and a patient pertains not only to the relationship between two people, but also to a specific spell or episode of illness. So, just because a doctor treated someone for flu symptoms in 2018 would not mean that they would be obligated to treat them for, say, a scalp laceration in 2020 because it's a specific incident or a specific a different specific spell of illness. In the Eddingfield case, the one we discussed earlier, just a few moments ago, although the doctor had been the family doctor, uh, he did not have a current relationship, and he had not treated this woman during her current spell of illness. So relationships have to be established and they have to be renewed periodically. It may not take much to form a relationship, but still something has to be in place. Examples where a relationship can be formed from conduct, and other examples where relationships will not be held to have been formed by conduct are as follows. Um, where a doctor has a phone call with a patient where the patient describes symptoms and the doctor dispenses medical advice over the phone or even gives a prescription, this will generally be held to form a doctor patient relationship. On the other hand, if two doctors are playing a round of golf and Dr. A decides to consult with Dr. B about a patient of his and asks his advice about a course of treatment, this will not form a relationship between the doctor who was consulted and the patient of Dr. A. This is certainly the type of collaboration we hope that would occur in the medical profession, and we don't want to discourage it. But certainly, if Dr. B thought that by answering Dr. A's question, he would be sucked into a uh, physician-patient relationship with a patient he had never met, he might not answer the question. So, no relationship under those circumstances. Often we go to doctors because our employer wants us to have a pre employment physical, depending on the nature of our job, or maybe we sign up for life insurance or health insurance, and the insurance company wants us to have an exam before they commit to writing the insurance policy. Those doctors' relationships are with the third parties, that is, with the insurance company or with the employer, and not with the patient they are examining. There is no physician patient relationship formed there. Next, it's necessary for us to examine the duty of hospitals to accept and treat patients. In the not so distant past, hospitals were treated like doctors in the sense that historically the no duty rule also applied to them. Currently, though, hospitals are prohibited from arbitrarily refusing to admit people. As you know, we have paying patients, we have insured patients, and we have indigent patients. All of them are entitled to access to the hospital and to treatment in the hospital under the law today. Private hospitals have traditionally been reimbursed for charity care provided, and charity care is now stretched to the limits, uh, leading to the phenomenon known as patient dumping, where indigent patients are being turned away from private hospitals and referred to public hospitals. Uh, to battle this, litigation has occurred over the years. So, a general duty to provide care was established in the case of Wilmington General Hospital versus Manlove, a Delaware 1961 decision. In that case, it was held that hospitals have to act reasonably in patient selection decisions. Certainly, a hospital that's not equipped to deal with a particular medical crisis presenting at the hospital has the right to turn that patient away and refer them to a place where they can actually get help. However, they have to act reasonably in that regard. In Manlove, a critically ill infant was turned away from the ER because the infant's doctor did not have hospital privileges. The child died, and his death was attributable to the time lost and the detrimental reliance of the parents who brought the child to that hospital on the belief that the hospital would provide the treatment needed to save the child's life. Um, Here, the court held that the hospital did not act reasonably and did have a duty to treat this child, held them responsible for the child's death. But the application of this case was kind of limited to the emergency situation. There's a theory of duty that applies to hospitals, which is called the quasi public theory of duty. And the sense of it is that the law, in some cases, and the law changes and varies from state to state, but in some states, it's held that hospitals uh, provide a quasi or semi-public duty to the community. They have a role in the community. They're licensed by the state. They receive public funding, and that therefore they should, just like public hospitals, have the same duty to accept and treat patients. This doctrine is not widely accepted around the country, but it is found from place to place. Emergency care, however, is a different animal. And here, state and federal laws impose a very clear duty on hospitals to provide emergency medical care, regardless of the ability to pay. Some of the laws, in attempting to define what an emergency is, are unduly restrictive. Some will say that treatment and emergency is actually one medical condition where the treatment required would be necessary to prevent the immediate loss of life or limb. That's pretty narrow. But the trend is to expand this definition under a Supreme Court case out of Arizona. The rule was very liberal and said that the hospitals had duties to treat all comers, all patients, regardless of their ability to pay, relying on the quasi-public duty, which we talked about a few moments ago, and would apply to all necessary treatments, not just to stabilize and then to transfer. But the granddaddy of all laws related to the duty to provide emergency care is the Emergency Medical Treatment and Active Labor Act, which is we will call EMTALA for short. It's a federal law. The reason why the federal law gets to regulate it is because the federal government provides monies, grants, support in a financial way to hospitals around the country. And because of that, they have something to say about who the hospitals take. So all hospitals that receive Medicare payments must comply with EMTALA. EMTALA provides a private cause of action, that is a right to sue for failure to comply with the law. And failure to comply with the law could result in a fine of up to $50,000 per incident for noncompliance by hospitals. And the fine could also be applied to doctors. So remember, we said before that doctors had no duty to treat. But sometimes when they're working out of a hospital, especially in the emergency context, EMTALA will impose a duty on them. We'll talk a little bit more about that later. EMTALA provisions are designed to prevent patient dumping of indigents and uninsured. EMTALA requires that hospitals screen to determine whether an emergency exists, and that if an emergency does exist, the hospital is required to treat to the point of stabilization. And stabilization is defined as enough treatment to prevent material deterioration. Uh, Someone with deep facial lacerations or head trauma, bruising, dental damage can be bandaged and an IV provided to stabilize the blood pressure before being transferred to another hospital. In the example used in your book, the transfer to a VA hospital was okay after stabilization under EMTALA. However, you should be aware that common law rules like that in Arizona, which say that all patients must be treated regardless and all necessary treatments provided, may actually be more liberal than EMTALA is. Now, a little bit about patient dumping. Uh, Patient dumping is a phenomenon all over the place, but it seems to be heavily concentrated in urban areas where there's a homeless population and an indigent population. Dumping involves typically directing an ambulance to another hospital. This would be a private ambulance, a private hospital's ambulance picking up a patient, determining ability to pay or homeless status, and then turning around mid trip and taking that patient to a public hospital. Under EMTALA, a patient must come to a hospital in order for EMTALA to be invoked. However, under EMTALA, once they put the patient into the hospital's ambulance, it is considered as if he is in the hospital or she is in the hospital. A lot of people think EMTALA is not really effective and could be improved, not well drafted. But it is central right now to the law of medical access as we understand it. Doctors who belong to healthcare organizations uh, can have a higher duty over and above that no duty rule we spoke about up front. Because if doctors could continue to refuse to treat, how could hospitals then be obligated to treat? Hospitals treat through the use of the doctors who practice within its walls. If the doctors within their walls can decline to treat, then the hospitals are rendered ineffectual. So, under EMTALA, in emergency situations, doctors also can be fined for EMTALA violations. Contractually, also, when a doctor applies for privileges at a hospital, the hospital, through the contract, can bind that doctor to treat under emergency circumstances those that the hospital has a duty to treat. And finally, in a managed care network, a doctor may also have an obligation to treat patients who have a relationship with the plan. There is a lot of material in the book on the wrongful denial of treatment, and I would encourage you to read through it. But a lot of it is, as you might expect, the wrongful denial of treatment on the basis of racial or ethnic discrimination, um, disability discrimination, ADA, the Rehabilitation Act, and in these cases, there are elaborate legal principles which apply to them, but for the most part, uh, the hospitals and certainly the doctors are not permitted to deny treatment on the basis of race, ethnicity, or other protected categories. One of the exceptions would be, of course, the doctor and the hospital have to be equipped to help that patient. If they lack the expertise or the facilities to do so, then that would be the reason for turning the patient away and referring him or her elsewhere, but not on racial or ethnic or other suspect classifications alone. Principles of due process and equal protection under the 14th Amendment also apply to the right to medical access. Publicly funded hospitals can't discriminate against temporary residents. and the parens patriae doctrine, which we talked about as a constitutional principle that the government acts on behalf of the people, would hold that institutionalized people are entitled to treatment, and obviously those who were incarcerated, those in prison under the Eighth Amendment, are entitled to adequate, competent medical treatment. Failure to do so would violate the cruel and unusual punishment prohibition under the Eighth Amendment. Most of you know who have worked in the hospital context that patients get a Bill of Rights, which hospitals must sign on to in order to receive accreditation. And This is something certainly that will benefit patients, but most patients, under the stress of having a medical condition which is causing some anxiety with them or with their family, are not always in the best position to advocate for their rights in the hospital. This is where hospital social workers can serve a great advocacy role in taking the part of the patient and fighting or advocating for their right to access to treatment. Okay, so now that a treatment relationship has been formed, let's assume that one has been formed, all good things come to an end. So relationships of all sorts have beginnings, middles, and ends. How does a physician or a hospital end its relationship with a patient? This is not as easy as you might think. The improper termination of a relationship between a physician and a patient is considered abandonment, the improper intentional termination of the patient relationship. Negligent abandonment is the subject of a malpractice case, a doctor who engages in a negligent abandonment, just a neglect of a patient, can be sued for malpractice, which is professional negligence. So the steps to be undertaken to accomplish an effective legal and proper termination are as follows. And First of all, a physician seeking to terminate must provide all necessary care up until termination. And the termination can be initiated by the patient or can be initiated by the provider, but only after adequate notice and an opportunity to secure replacement care. So let's talk about what that means. When can a doctor terminate a patient? Well, a doctor can terminate a patient really for no reason at all. Shouldn't be a discriminatory reason under the Constitution or the Civil Rights Act, which we talked about a few moments ago, but just personality conflict, for instance, wants to cut down the volume of his practice. Whatever the story is, a doctor can generally terminate a patient relationship as long as he does so on proper notice and takes the proper steps to arrange for substitute care. So you can't terminate a patient and then leave it up to the patient to find substitute care. You have to assist effectively in the process of securing that substitute care. What if the money runs out, though? What if a patient loses the insurance and has no ability to pay a doctor? Must the doctor persist? Is indigency a reason for a doctor to terminate a relationship? Well, the law doesn't require that physicians work for nothing. And the cases across the country are mixed, meaning some hold that the doctor has a higher duty and some hold that the doctor has no duty. The question is the discharge on the basis of a substantive question, or is it on the basis of a purely procedural one, like means to pay? There's a case discussed here about a cranky patient who was on dialysis, an alcoholic who continues to drink and drug and is discharged because despite warnings throughout, he continues to abuse substances while on dialysis. This doctor discharged the patient, gave notice, but did not arrange for a replacement care. Sometimes it's difficult to place a patient, especially a difficult one, in a replacement situation. So the bottom line here is, though, the doctor must make some efforts to find replacement care for the patient it seeks to terminate, and the termination shouldn't be simply a quick note and don't come back tomorrow. There should be some reasonable time element provided. I want to talk briefly about some of the important legal aspects of the relationship. What does it mean? We know that a doctor who's engaged by a patient has a duty to provide good professional care. But beyond that, what are some of the other duties that a doctor, or even a hospital for that matter, owe to a patient? Well, the first of these is we must understand that a doctor is a fiduciary. And the word fiduciary comes from the Latin word for trust, because the relationship between a doctor and a patient is a relationship of trust or confidence, just as the relationship between a lawyer and his client is a relationship of trust and confidence. Fiduciary duty is the highest standard of duty that's imposed by the law on anyone. Because when you think about it, a patient going to a doctor entrusts his well being, perhaps even his life, to the care of the doctor, and is completely dependent on the doctor in most cases for information. Some patients do their own research to check what the doctor is saying against what they learn for themselves, but most patients completely abandon that and put themselves in the hands of the doctor that they trust. Trust, again, is the key word. Another element of this relationship is the relationship and the duty to maintain confidentiality. A couple of weeks ago, we talked about HIPAA and our obligation to keep patient medical information safe and secure. Confidentiality is at the very core of the fiduciary relationship, and the patient expects that the information he or she gives to the doctor, or that the doctor learns through his treatment of the patient, remains confidential. The Hippocratic Oath supports this duty to the patient, and the AMA Principles of Medical Ethics, certainly in a more modern document, emphasize very heavily the duty of confidentiality. The purpose is what we call utilitarian or useful. Why? Because confidentiality encourages patients to seek treatment. Remember, we talked about the public health benefit of confidentiality. In a public health crisis, how do we get people who are infected or possibly infected or part of the tracing operation to be completely candid with our public health officials unless they know that their information will be kept confidential? So without this duty of confidentiality, patients might be reticent to disclose treatment, to disclose information, which is necessary to undertake the proper treatment. The breach of the duty of confidentiality can result in a malpractice case, a suit for invasion of privacy, breach of fiduciary duty, breach of contract, or even emotional distress. If you could imagine that the leaking of some sensitive information could actually distress someone to the degree where they become incapable of working or carrying on in society. This is possible. State licensure laws, of course, require confidentiality. The rules of evidence that lawyers deal with say that relationships between doctors and patients are privileged and can only be disclosed under certain circumstances subject to protection by the court. This privilege of confidentiality exists until it is waived, and it can only be waived by the patient. Now, we waive confidentiality to a limited degree when we go to a doctor or a hospital and we sign those forms, because as we know, the information gathered in that context is going to be shared with insurance companies. That's one of the exceptions. In the public health field, of course, some of the information that's disclosed, which is a public health concern, would have to be disclosed by law. And sometimes in the federal drug and alcohol assistance programs, it's required. And genetic testing, sometimes the patient will be asked to waive. Ancestors or relatives of someone with a genetic predisposition for one condition or disease or another might be interested in a limited waiver of confidentiality so that those who share the genetic predisposition could be forewarned and take the appropriate take the appropriate um, steps to address the problem. Statutory provisions related to confidentiality, of course, include HIPAA. And as we discussed previously, consent to the disclosure of information, medical information, is not required for many disclosures, such as billing, insurance, and public health, where there's a duty to disclose. Consent is required, though, where the information is being used for research and family disclosure based on genetic predisposition. There are civil and criminal penalties which may apply for violations of confidentiality, and there are licensing repercussions in the sense that a practitioner who violates confidentiality could have his or her license suspended or even permanently uh, removed and be barred from the practice. A doctor also has a duty to third parties, not the patient, sometimes. And that duty may compete with the duty of confidentiality to the patient. Let's think of an example. Um, a state public health official is required to report an individual to protect individuals and the community from communicable diseases, but at the same time, in order to do that, they may have to disclose confidential information. Doctors who learn things which are potentially indicative that a patient is going to harm a third party may have a duty to disclose that to law enforcement officials. We talked about the Tarasov case back when. Sometimes the failure to report to a third party can result in liability for the doctor. Violent crime reports, including knife and gunshot wounds, um, are really put in place to help with policing more so than to protect the public. So uh, it's really a close question as to whether or not confidence should be protected or information should be disclosed to third parties. But basically, the inquiry should be whether or not there will be any harm will result if the confidential information is disclosed, and whether there's a legal requirement that the information be disclosed. We talked about Tarasov, I believe, earlier, and this is Tarasov versus Regents of California, where the doctor is seeing a violent psychiatric patient who threatens um, to hurt a third party, not a patient, and deals with the duty of the doctor to inform the law enforcement, but also possibly to inform the third party potential victim if he happens to know who it is. The law is quite vague in this subject, and many physicians aren't quite sure how to handle it. Other examples are: suppose a doctor sees a patient and is prescribing a medication for him, which the doctor knows should really take the patient out of the driver's seat. While the patient is on this med, he should not be driving. Yet he sees the patient jump in the car after the appointment and drive away. Uh, is he obligated to report that to the police? So there is some tension between the competing duty to the patient and the duty to the community and the third parties who might be impacted. A couple of other interesting examples there are set forth, and you should read those sections in the book and get a good understanding of it. Also, when you read the genetic information section in the book, um, read alongside that the material I've given you on the immortal life of Henrietta Lacks and the genetic information which has been derived from her ovarian cells harvested during her surgery without her consent. And yet, the research conducted on the basis of the work done on those cells has probably saved millions or billions of lives around the world in the years which have followed. In some cases, in some states, state law will provide some immunity to healthcare providers who make good faith decisions, that is, after careful consideration and investigation of options and consulting with ethics resources, they decide that a disclosure is necessary in the interest of uh, uh, protecting the public or protecting an individual. And these laws would immunize that physician upon disclosure from liability for the failure to protect the information. Finally, we come to informed consent. I've mentioned this a couple of times along the way. This is really important. It really begins with the idea that as patients, we have autonomy to make our own medical decisions. We have privacy rights, what we call under the 14th Amendment case law, decisional privacy and bodily privacy, to decide whether or not to take a treatment or not take a treatment. And informed consent is a big part of that because how can a patient make a decision about a medical treatment unless the patient has been told what the treatment is, what it's for, why it's necessary, what the possible side effects would be, etc., etc. So, informed consent should be understood as requiring the doctor to disclose sufficient information to a patient to allow him or her to make an informed medical decision. Informed consent puts the patient in what we call the driver's seat, and it's really at the very heart of the fiduciary relationship. Remember, the patient is trusting the information provided by the doctor. A patient who was not provided with informed consent can sue the doctor for that failure if the course of treatment carries an undisclosed risk and the non-disclosure of the risk breaches a standard of care. That is, most doctors in the profession would understand that this risk had to be disclosed. And three, that the risk which was not disclosed actually caused the injury. And had the patient known, he might have decided against taking the treatment. So, before any liability can apply and before informed consent can be given, and a treatment and the treatment which follows, you need two elements. We need to understand that the patient has the mental capacity to understand the information being imparted by the doctor. And we need to know that the patient has volition, that is, the ability to agree to something, that they're not being forced or coerced, or that they're not under the influence of a drug, that they have free will. Their free will is completely intact. And when they say, yes, I'll take the treatment, we can rely upon that. So, what is it that a doctor must disclose? Certainly not everything. Should a doctor, for instance, disclose that it's possible that during the course of your bypass surgery, a meteorite will come screaming out of outer space, crash through the hospital roof, and into the operating room and hit you right on the uh, stretcher? No, that's not a foreseeable risk. That doesn't have to be disclosed. But the diagnosis has to be disclosed. The nature and the chance of success for the treatment being recommended has to be disclosed. All of the foreseeable risks of the treatment and the alternatives to the treatment must be disclosed. And of course, informed consent has to be obtained in a form which makes sense. So, for the most part, for the protection of the healthcare provider and the patient, informed consent is obtained in written form. The risks are written down, usually on a form, handed to the patient. Patient's given an opportunity to read it, and is given an opportunity to ask questions about it or have portions of it explained. Unfortunately, the forms can be a bit complicated. The patient is under duress because of the medical condition, and the forms are written by lawyers. It's not the most easy language in the world to understand, and we can only hope that the patients are really getting the gist of what's being disclosed to them. There is a professional standard of disclosure, and a physician should disclose all that a reasonably competent physician under the circumstances should disclose. This is called the objective standard, and it's bad for patients because a patient trying to prove a breach of informed consent would actually have to bring an expert doctor into court to prove that a reasonably competent physician would not feel the need to disclose these risks. Patients have informational expectations. Uh, which may not be met by this disclosure and may not be met under this objective standard. Now, the doctrine is designed to enhance patient autonomy, but it ends up deferring through this objective standard to the collective judgment of doctors as to what you, the patient, need to know. That seems a little bit ironic to me. There is a minority rule applied in some states which say that all information reasonably necessary to the decision of a reasonable patient must be disclosed. But who is a reasonable patient? How do we define that? Medical decisions are highly personal. They're value laden. Every people's priorities are different. A man with prostate cancer, for instance, if you have two patients like that, one might be just wanting to make sure that he can live out his life at a high level of quality and enjoy his grandchildren. Another man might be more interested in making sure that his sexual function is intact or his urinary and bowel functions are intact. Everyone has different expectations headed into a procedure. Perhaps these decisions, some would argue, should not be left to professionals. The objective standard, the reasonable patient standard, are all different from the this patient standard. The this patient standard would really lead to no standard at all, which would be hard to administer because what a doctor would need to disclose to a given patient would be, in each case, perhaps something different. The refusal to accept medical treatment is also subject to informed consent. This is called informed refusal. I'm sure you've all encountered the cranky patient who wants to get out of the hospital at all costs and will escape at night under the cover of darkness or even bribe an orderly to sneak him out a side door. However, a doctor has a duty, if he knows, and a hospital has a duty, if they know, to disclose to the patient the risk of refusing. And they must do this in a forceful way. They must make the patient understand that if the treatment is not taken, if the patient doesn't stay in the hospital, the following things might happen. In some states, it's been argued that a physician is required to disclose to a patient his skill level. This is not favored by everyone, and not every patient would insist on having the doctor with the highest experience. And this would really lead to perhaps a stifling of professional development in the medical field where younger doctors with less experience are really not getting into the action. That wouldn't be good long term for our system. Informed consent only applies to medical matters, should seem obvious. For instance, a doctor has no duty to tell a terminal cancer patient that he ought to get his financial affairs in order and perhaps draw a will. Um, and then finally, modifying the terms of the relationship. Doctors cannot ask patients to waive the right to sue for malpractice. When a doctor and a patient get together, the doctor has the advantage first time and every time. He has the upper hand. The patient is in pain. The patient has a disease. The patient has anxiety. The physician has the potential solutions. So, because of the disparate bargaining power, physicians will not be allowed to ask patients to waive the right to sue for malpractice. It's also a violation of their fiduciary duty to the patient.